You know, many times as we go through life, we try to decide what is it that we need to set aside for later, especially if things happen in the future. I'm specifically talking about estate planning. And joining me now, of course, is Jeffery Williamson, who is an expert on this, tax attorney and estate planning attorney. Thanks so much, Jeffery, for joining us on the Southern scene. So let's talk about estate planning, because when you think about this, it really has changed over the years. But for some of our viewers who may not even be familiar with estate planning, I mean, what is that all about?
Yeah, when people typically think about estate planning, they may think, my will. Somebody's going to write a will for me. The focus has been over the past 5 to 10 years about the estate tax and minimizing our estate and not paying any tax. With the changes of the laws, the exemption has gone, the estate tax exemption has increased substantially. That's no longer the focus. The focus of modern practitioners, those that are expert in the field, is more about planning during life, protecting our assets, preserving what we have, so there is something to leave to our posterity.
When is the time that we should be focused on this?
Everyone should have an advance directive for health care and a durable financial power of attorney. Those aren't the documents that are talked about a lot, but they're very important, because if you don't have them and something happens, an unexpected accident, you've lost control and you're now in the court system. Long-term care planning, elder law, which is one of the areas we specialize in, really the time to look at it is when you're in your mid to late 60s, early 70s, to be sure that your assets are protected should you have a catastrophic long-term care expense.
Now, let me ask you this, Jeffery. Now, we've heard so many people talk about the word trust. What does that mean exactly when you refer to a trust?
Well, it can mean a lot of different things. A trust is a contract, but it's a contract that has a big body of law behind it between the grantors, that is the person putting property in a trust, the trustees, the person managing the property, and then the beneficiaries. The nice thing about these irrevocable trusts that we use a lot in long-term care planning is you can't be your own trustee, but you can still retain some of the benefits of the assets once you put them in trust. So it's not like making a completed gift where you have to just walk away from it.
Now, you mentioned assets. What about certain things like your home? I mean, how do should I put that inside of a trust?
Well, each situation is different, so I need to talk to each client individually, but generally it is a good idea. You mentioned about putting trust for your children, and that's certainly a wise thing to do, but these trusts are mainly to protect for the benefit of the client, so that they'll have their assets and it won't be consumed in long-term care. Your home is generally not counted for purposes of qualifying for Medicaid. If you don't have long-term care insurance and you have to have skilled nursing care, your only two options are to privately pay or qualify for Medicaid. Even though the home is not counted, typically, the state will put a lien on it after you're gone for the care that they provided for you. So if you want to protect your home, not only from keeping you from qualifying for Medicaid, but also from what we call estate recovery, you have to put it in a trust or get rid of it some way.
What do you mean when we talk about Medicaid look-back rule? Now, that's something that I am not familiar with at all. So Medicaid look-back rule.
A lot of my clients come in and they get the rules with gift and estate taxes confused with Medicaid. Medicaid does not care about any exemptions that you might get under the federal code. Any uncompensated transfer, read that as a technical legal term, but read that as a gift, that you make within 60 months of applying for Medicaid could be subject to a penalty. So that's why it's important to plan early. If you set this trust up and you put those assets in trust and 60 months goes by before you need care and you don't apply for Medicaid until after that 60 months is up, those assets will neither count against you for purposes of qualifying for Medicaid, and they won't be subject to a penalty, and they'll be protected.
Is this something that an individual can do themselves or should do themselves?
Yeah, the last question is the best question. Let me give you one example. This is a technical legal example, but it's very important. Georgia just amended its trust code in 2010. So for you to get the Spendthrift Protection, the creditor protection I talked about, there has to be certain specific language in that Spendthrift code section. Well, in that Spendthrift section of the trust, if you go online, that trust might have been drafted for Delaware law or Nevada law, you may not have that language, and you wouldn't know if you weren't an attorney. So you spent, rather than spending maybe more money in an attorney's office, you spent whatever, several $100s online, but the document you have could be worthless.
Now, if somebody's watching right now and they want to pick up the phone or they want to come in, what is the process that they're going to go through when they come and see you?
They just call the office and make an appointment. I generally don't charge for an initial consultation because I want the client to be relaxed. The initial consultation is the time for them to tell me everything. So if they're busy looking at the clock, wondering when their hour's up, that's not the way to begin the process.
Okay, well, Jeffrey, thank you so much for going through and providing us with great information on estate planning, and I'm so glad that we have you on the show and we can call on as the expert where this is concerned.
You're welcome.